UDRP service providers are required to publish their decisions online, but in recent years, an increasing number of cases have redacted or withheld the name of the domain name registrant. In this video, I'll explain why. Hi, it's Doug Isenberg, and the case I'll focus on to illustrate the issue of redacting names is a decision from WIPO in May 2021 under the UDRP, the Uniform Domain Name Dispute Resolution Policy. The case is titled Lennar Pacific Properties Management Incorporated and Lennar Corporation versus Registration Private, Domains by Proxy LLC, and Name Redacted. It involved the domain name lennarcorporation.com. The two complainants are apparently affiliated companies that own rights to the Lennar trademark, and the respondents are a popular privacy service, Domains by Proxy, and as you can see from the caption, Name Redacted. The substantive facts of this case, according to the decision, are pretty brief. The registrant of the lennarcorporation.com domain name, known as a respondent in a UDRP proceeding, had no affiliation with the owner of the Lennar trademark, but used it, as the decision said, to engage in potentially fraudulent behavior whereby respondent posed as an official human resources representative of complainant and sought to obtain sensitive personal and financial information from prospective job applicants of complainant. Now, it appears that when Lennar filed its complaint, the registrant of the domain name was probably identified in the WHOIS database as simply Registration Private, Domains by Proxy LLC. And this means that the registrant of the domain name used a privacy service to hide its identity. These privacy and proxy services are popular, but often controversial, and I talk about them in more detail in episode 10 of my masterclass on domain name disputes. In this case, it seems that during the administrative compliance process, which occurs immediately after a UDRP complaint is filed, the registrar provided information about the so-called underlying registrant to WIPO, which then forwarded the details to Lennar. Now, this is a not unusual occurrence and sometimes provides trademark owners with additional helpful information that can be used not only in the immediate UDRP proceeding, but also perhaps for other purposes as well. But in this case, as sometimes occurs, it appears that the underlying registrant information itself was fraudulent. In other words, not only did the registrant of the domain name use a privacy service to hide its identity, but it provided a false identity to the registrar itself. And in this case, the false identity was actually the name of someone who worked for Lennar, the complainant. If this sounds confusing or sneaky, that's actually the point. Cyber squatters who engage in illegal activity often take additional steps to hide their identities and confuse both their intended victims as well as the trademark owners they're targeting. So while the normal practice in UDRP proceedings would be to publish the name of the underlying registrant, in cases like this one, panelists sometimes ask the UDRP provider to remove or redact a false identity. And here's what the panelists wrote in the lennarcorporation.com decision. Respondent appears to have used the name of a third party, a human resources manager for complainant, when registering the disputed domain name. In light of the potential identity theft, the panel has redacted respondent's name from this decision. However, the panel has attached as Annex 1 to this decision an instruction to the registrar regarding transfer of the disputed domain name, which includes the name of respondent. The panel has authorized WIPO to transmit Annex 1 to the registrar as part of the order in this proceeding and has indicated Annex 1 to this decision shall not be published due to the exceptional circumstances of this case. In other words, publishing a fake name in the decision for the domain name registrant, a name that corresponds to an employee of the complainant, would serve no purpose other than to falsely accuse an innocent person of being a cyber squatter, which is why the published decision in this case includes name redacted in lieu of an actual name. This is not an unusual outcome. As of this recording, 273 decisions at WIPO list name redacted as a respondent. Sometimes that's because the registrant might be falsely identified as an employee of the complainant, as happened in the Lennar Corporation.com case, and other times it might be a person completely unrelated to the dispute, and publishing their name would only further victimize them. So, what can trademark owners learn from this case and similar UDRP decisions? If nothing else, these cases are a stark reminder that cyber squatters often employ multiple tricks to hide their true identities. But trademark owners should also know that when they identify an obviously false name for a registrant, especially where that name might be associated with identity theft, they can request that the fake name be redacted from the decision because publication would only cause further harm. If you want to learn more about the UDRP, please check out my masterclass on domain name disputes, as well as other resources on my GigaLaw website. And be sure to subscribe to the GigaLaw YouTube channel to be notified of future videos discussing other UDRP cases. Thanks for watching, and see you next time online.